Question 1. During a comprehensive review of a process that needs improvement in veterinary malpractice law, a case arises where a pet owner sues a veterinarian for negligence. The veterinarian performed a routine spaying procedure on a dog, but complications arose, leading to the dog's death. The pet owner claims emotional distress and seeks damages for pain and suffering. What is the most likely legal outcome based on current veterinary malpractice laws in the United States? A. The pet owner will be awarded full damages, including emotional distress, since pets are considered family members under the law. B. The veterinarian will not be liable because animals are considered property and emotional distress claims are not typically recognized. C. The pet owner can recover the market value of the dog, but not damages for emotional distress. D. The veterinarian will be criminally charged for negligence and the pet owner receive compensation for the full cost of treatment and emotional harm. Answer. C. The pet owner can recover the market value of the dog, but not damages for emotional distress. Explanation. Under current U.S. veterinary malpractice laws, animals are generally considered property, meaning that the damages awarded in a lawsuit are limited to the economic value of the animal rather than emotional distress or pain and suffering. Courts have historically ruled that pet owners cannot recover non-economic damages such as loss of companionship or emotional distress in malpractice cases. Legal precedent. Courts have consistently ruled against emotional damages for pet loss. For example, in Strickland v. Medlin, the Texas Supreme Court ruled that owners could not recover sentimental damages for a pet's death. Exceptions. Some states allow limited damages if the veterinarian's actions were particularly reckless or intentional. However, the general rule still applies. Criminal charges. Veterinarians are rarely criminally charged for malpractice unless they engage in willful or egregious misconduct. Question 2. When implementing new protocols in a shared environment involving the treatment of laboratory animals, a biomedical research facility must ensure compliance with federal regulations. The Institutional Animal Care and Use Committee (IACUC) has identified an experiment that involves painful procedures on rodents without anesthesia. Which of the following actions is the best legal course under the Animal Welfare Act? A. Proceed with the experiment without anesthesia, as rodents are not covered under the AWA. B. The facility must obtain explicit approval from the IACUC and justify why anesthesia is not being used. C. The researchers should submit an alternative experiment plan that does not involve pain. D. The experiment must be halted immediately, as any painful procedure without anesthesia violates federal law. Answer. B. The facility must obtain explicit approval from the IACUC and justify why anesthesia is not being used. Explanation. The Animal Welfare Act (AWA) is the primary federal law governing the treatment of animals in research. However, it does not cover mice, rats, and birds, which means that institutions are not legally required to follow its anesthesia provisions for these animals. However, facilities receiving federal funding must comply. Additional regulations from the Public Health Service (PHS) policy on humane care and use of laboratory animals, which requires adherence to the Guide for the Care and Use of Laboratory Animals. IACUC oversight. The Institutional Animal Care and Use Committee (IACUC) is required to review and approve all research involving animals. If an experiment involves procedures causing pain or distress, the researcher must provide scientific justification for not using anesthesia or pain relief alternatives consideration. While researchers are encouraged to consider alternatives, the law does not outright prohibit painful procedures. The key is that the pain must be scientifically justified and approved by IACUC. Halting the experiment. The AWA and PHS do not mandate that all painful experiments be stopped, but they do require oversight and compliance with humane care standards. Question 3. In a case where multiple parties have different objectives regarding the legal personhood of animals, a non-profit organization petitions a court to recognize a chimpanzee as a legal person, arguing that the animal exhibits advanced cognition, self-awareness, and complex emotions. The opposing party argues that legal personhood should be restricted to humans and certain corporate entities. Based on legal precedents in the state animal personhood law, what is the most likely ruling? A. The court will grant personhood to the chimpanzee, setting a precedent for all non-human animals. B. The court will reject personhood but may recognize certain enhanced rights for the chimpanzee. C. The court will refuse to hear the case as animals are clearly defined as property in all legal systems. D. The court will require a legislative decision before making a ruling on personhood for animals. Answer. B. The court will reject personhood but may recognize certain Enhanced rights for the chimpanzee. Explanation. The debate over legal personhood for animals has gained significant attention, particularly in cases brought by organizations like the Non-Human Rights Project LP, which has argued for granting limited legal rights to highly intelligent animals. Legal precedents. Courts have generally rejected full legal person animals but have sometimes recognized enhanced protections. For example, in matter of Non-Human Rights Project Inc. v. Lavery, New York courts ruled that chimpanzees lack the ability to bear legal responsibilities, thus they cannot be legal persons. Partial rights considerations. In some jurisdictions, courts have acknowledged the complexity of animal cognition and suggested that certain animals deserve stronger legal protections, even if not classified as legal persons. Legislative role. Many legal scholars argue that any change in animal personhood must come through legislation, not court rulings, as courts traditionally defer to legislatures on major legal redefinitions. Question 4. In a high-stakes environment where multiple challenges intersect, a state wildlife agency is considering a new regulation restricting private ownership of exotic animals due to increasing public safety concerns. However, a coalition of exotic animal owners argues that this infringes upon their property rights in existing state laws allowing such ownership under permit conditions. The agency also faces legal challenges from animal organizations that argue the proposed regulations do not go far enough to protect animal welfare. Which of the following legal principles is most relevant in determining whether the state wildlife agency has the authority to impose such restrictions? A. The Dormant Commerce Clause. B. The state's police power. C. The Takings Clause of the Fifth Amendment. D. The Supremacy Clause. Answer is B. The state's police power. Explanation. States have broad police powers to regulate for the health, safety, and welfare of their citizens, which includes regulating exotic animal ownership. Courts have generally upheld laws restricting or banning private ownership of exotic animals as long as they serve legitimate public interest, such as preventing harm to the public or protecting animal welfare. A. The Dormant Commerce Clause is incorrect because while it limits states from enacting laws that unduly burden interstate commerce, states have significant leeway in regulating animal ownership when public safety is concerned. C. The Takings Clause of the Fifth Amendment does apply in some cases where government regulations effectively deprive an owner of their property without just compensation, but courts often rule that public safety concerns justify such regulations. D. The Supremacy Clause is not relevant because this case does not involve conflict between federal and state law, rather, it concerns state regulatory authority. Legal precedents such as Q or V. Selner, 2017, where courts upheld state restrictions on exotic animal ownership, reinforced the state's power to impose such regulations. Question 5. During a comprehensive review of a process that needs improvement, the federal government is considering amendments to the Animal Welfare Act to strengthen enforcement mechanisms against laboratory research facilities violating welfare standards. Under the current framework, the AD oversees enforcement, but reports indicate inconsistencies in inspections and penalties. Which of the following would be the most legally viable reform? A. Allowing private citizens to sue laboratories directly for AWA violations. B. Granting more regulatory authority to state governments to enforce the AWA. C. Increasing federal penalties for repeat violators and mandating more frequent inspections. D. Transferring enforcement authority from the EDO, a newly established independent agency. Answer is C. Increasing federal penalties for repeat violators and mandating more frequent inspections. Explanation. Strengthening federal enforcement mechanisms aligns with the purpose of the AWA and ensures a more uniform regulatory framework. Federal agencies, particularly the USDA, already have the authority to fine violators, but increasing penalties and inspections would enhance compliance. A. Allowing private citizens to sue laboratories directly is incorrect because the AWA does not provide for a private right of action, meaning individuals cannot directly sue violators in court. B. Granting more regulatory authority to state governments is problematic because the AWA is a federal law, and delegating enforcement to states could create inconsistencies in application. D. Transferring enforcement authority from the ESD independent agency would require major legislative overhaul and is unlikely to be politically feasible. Case law such as Ald v. Glickman 1998 highlights the limitations of private enforcement under the AWA, reinforcing the need for stronger federal oversight. Question 6. When dealing with a complex system that shows occasional inconsistencies, local governments often struggle to enforce animal cruelty laws uniformly. One issue arises when animal hoarding cases are prosecuted differently depending on the jurisdiction, leading to concerns about equal protection under the law. What legal principle should guide efforts to standardize the enforcement of animal cruelty laws? A. Preemption under federal law. B. The Equal Protection Clause of the 14th Amendment. C. The First Amendment's right to privacy. D. Sovereign immunity for state agencies. Answer is B. The Equal Protection Clause of the 14th Amendment. Explanation: this clause requires states to apply laws fairly and consistently to all individuals. If animal cruelty laws are enforced inconsistently, it could lead to claims that similarly situated defendants are being treated unequally. A. Preemption under federal law does not apply because animal cruelty laws are primarily state and local matters, not federal. C. The First Amendment's right to privacy is not relevant, as animal hoarding cases generally involve public health and welfare concerns. D. Sovereign immunity for state agencies protects government entities from certain lawsuits but does not justify consistent enforcement. Court cases such as State v. 2018 illustrate how courts address disparities in enforcing animal cruelty laws. Question 7. In a situation where formal requirements conflict with practical realities, a pet owner sues a landlord under the Fair Housing Act (FHA) for refusing to allow an emotional support animal (ESA) in a no-pet apartment building. The landlord argues that allowing ESAs imposes an undue burden on property management. What is the most legally sound resolution? A. The tenant is entitled to keep the ESA regardless of landlord objections. B. The landlord can reject the ESA if it poses a direct health or safety risk. C. The FHA does not apply to rental properties. D. The landlord can charge additional fees for allowing the ESA. Answer is B. The landlord can reject the ESA if it poses a direct health or safety risk. Explanation: under the FHA, landlords must provide reasonable accommodations for ESAs, but there are exceptions if the animal would cause undue hardship or direct harm. A. The tenant is entitled to keep the ESA regardless is incorrect because reasonable accommodations are not absolute. C. The FHA does apply to rental properties, so this option is incorrect. D. Landlords cannot charge extra fees for ESAs, as doing so would violate FHA regulations. The case U.S. B. Barber 2020 reinforced that ESAs must be accommodated unless an undue burden exists. Question 8. During a comprehensive review of a process that needs improvement, a state legislature is considering updating its animal cruelty statutes to clarify the definition of necessary veterinary care. Some lawmakers argue that current laws are vague, leading to inconsistent enforcement. Which of the following would best address this issue? A. Expanding the definition to include routine checkups and preventive care. B. Narrowing the definition to include only life-threatening conditions. C. Aligning the state definition with federal animal welfare guidelines. D. Leaving the law unchanged to allow judicial discretion. Answer is C. Aligning the state definition with federal animal welfare guidelines. Explanation: federal regulations, such as those in the Animal Welfare Act (WAP), provide clear guidance on minimum standards for veterinary care, ensuring consistency. A. Expanding the definition to include routine care could impose unrealistic legal burdens on pet owners. B. Narrowing the definition to only life-threatening conditions would weaken protections and fail to account for chronic conditions. D. Leaving the law unchanged maintains legal ambiguity and could lead to continued inconsistencies in enforcement. Cases like People v. Sanchez 2020 highlight how vague statutes can lead to interpretations in court. Question 9. While investigating a complicated issue between different regulatory agencies, a city government is attempting to enforce stricter pet licensing laws. However, conflicting state and municipal regulations create uncertainty. Which legal principle is most relevant in resolving this conflict? A. Home Rule Doctrine. B. Commerce Clause. C. The Endangered Species Act. D. Habeas Corpus. Answer is A. Home Rule Doctrine. Explanation: many states grant cities home rule authority, allowing them to pass local ordinances unless they directly conflict with state law. B. The Commerce Clause applies to interstate economic activity, not local pet regulations. C. The Endangered Species Act is not relevant to general pet licensing. D. Habeas corpus concerns unlawful detention, not regulatory disputes. Precedents like Brooksville v. Smith 2019 demonstrate how courts analyze municipal authority and regulatory conflicts. Question 10. In a high-stakes environment where multiple challenges intersect, an animal shelter sues a pet store for selling sick puppies under false pretenses. The shelter argues that consumer fraud statutes apply to the case. What is the most legally sound argument? A. The pet store is liable under consumer fraud laws because it misrepresented the health of the animals. B. The pet store is protected by its sales disclaimers. C. Animal sales are not covered under consumer protection laws. D. Only veterinarians can legally challenge pet store practices. Answer is A. The pet store is liable under consumer fraud laws. Explanation: many states, including California and New York, have applied consumer protection laws to pet sales, especially when misrepresentation occurs. B. As disclaimers do not override fraud statutes. C. Animal sales are covered under consumer protection laws in many jurisdictions. D. Veterinarians have no special legal standing in such cases. The ruling in Moore v. PetSmart 2021 reaffirmed that deceptive pet sales can constitute consumer fraud. Question 11. When implementing new protocols in a shared environment, a federal agency revises its laboratory animal research guidelines. However, an animal rights organization sues, arguing that the revisions weaken animal welfare protections. What is the strongest legal argument for the agency? A. The agency has broad discretion in interpreting federal law. B. The organization lacks standing to sue. C. The agency is not subject to judicial review. D. Animal welfare laws only apply to pet owners, not laboratories. Answer is A. The agency has broad discretion. Explanation: courts often defer to agency expertise unless a law is clearly violated. Chevron deference. B. The organization may have standing if they can show direct harm. C. Agency actions can be reviewed if they contradict statutes. D. Animal welfare laws do apply to research labs. Cases like In Defense of Animals v. Ustia 2020 demonstrate the limits of intervention in agency rulemaking. Question 12. While analyzing the root causes of sequential problems in animal cruelty enforcement, a state attorney general reviews the use of felony charges in abuse cases. Some argue that felony penalties deter abuse, while others say they are applied inconsistently. What reform would best improve fairness? A. Standardizing sentencing guidelines for felony animal abuse convictions. B. Reducing felony charges to misdemeanors to prevent overcriminalization. C. Allowing judges complete discretion in sentencing. D. Eliminating felony charges for first-time offenders. Answer is A. Standardizing sentencing guidelines. Explanation: consistency in sentencing ensures fair application of laws. B. Reducing felony charges weakens deterrence. C. Unlimited judicial discretion leads to inconsistent outcomes. D. First-time offenses can still be severe. State v. Parker 2021 highlighted the impact of clear sentencing structures. Question 13. In a case where multiple parties have different objectives, a local government proposes a law banning the sale of fur products, but business owners challenge it as unconstitutional. What legal precedent is most relevant? A. Church of Lukumi Baboluwai v. City of Haile 1993. B. National Meat Assen v. Harris 2012. C. United States b. Stevens 2010. D. Endangered Species Act of 1973. Answer is B. National Meat Assen v. Harris. Explanation: this addressed state restrictions conflicting with commerce and industry interests. A. Church of Lukumi concerned religious animal sacrifice. C. U.S. v. Stevens involved free speech and animal cruelty depictions. D. The ESA applies to endangered species, not fur bans. Recent cases like California Fur Ban v. Retailers Association 2022 further test this issue. Question 14. During an emergency response where multiple areas are impacted, an animal control unit rescues pets from a disaster zone, but owners challenge their authority to seize animals. What law governs this situation? A. Pet Evacuation and Transportation Standards Act, Pets Act. B. Fourth Amendment protections against unlawful search and seizure. C. The Endangered Species Act. D. State nuisance laws. Answer is A. Pet Evacuation and Transportation Standards Act, Pets Act. Explanation: Pets Act mandates evacuation plans for animals in disasters. B. The Fourth Amendment does not apply when public safety is at risk. C. The ESA is irrelevant here. D. Nuisance laws do not override emergency response laws. Cases post-Hurricane Katrina reinforced Pets Act enforcement. Question 15. During a situation where multiple stakeholders have conflicting interests, what is the most effective way to reach a resolution? A. Facilitating an open dialogue to find common ground. B. Prioritizing the demands of the most influential stakeholder. C. Compromising by splitting resources evenly among all parties. D. Delaying the decision until the conflict resolves itself. Answer A. Facilitating an open dialogue to find common ground. Explanation. Facilitating open dialogue ensures that all perspectives are considered, leading to a balanced and sustainable resolution. Option B is incorrect because favoring one party creates resentment. Option C is incorrect because splitting resources evenly may not address actual needs. Option D is incorrect because delaying action can escalate the conflict. A collaborative approach fosters long-term cooperation. Question 16. While ensuring compliance with new industry regulations, a company realizes that some departments are struggling to adapt. What is the best course of action? A. Providing targeted training and support for affected teams. B. Enforcing strict penalties for non-compliance. C. Reducing regulatory requirements to ease the transition. D. Allowing each department to interpret the regulations independently. Answer A. Providing targeted training and support for affected teams. Explanation. Training and support help employees understand and implement regulatory changes effectively. Option B is incorrect because penalties don't address the root cause of non-compliance. Option C is incorrect because reducing requirements can lead to legal risks. Option D is incorrect because inconsistent interpretations cause compliance issues. Structured training program ensures adherence to industry standards. Question 17. During an evaluation of cost-saving measures that impact productivity, which approach would be the most effective? A. Identifying inefficiencies that can be eliminated without reducing output. B. Cutting employee salaries to reduce expenses. C. Eliminating resources used by lower-performing departments. D. Reducing staff to lower overall costs. Answer. By identifying inefficiencies that can be eliminated without reducing output. Explanation. Eliminating inefficiencies preserves productivity while achieving cost savings. Option B is incorrect because salary cuts lower morale and retention. Option C is incorrect because removing resources hinders performance. Option D is incorrect because reducing staff can lead to overworked employees. A balanced cost-saving strategy maintains efficiency and sustainability. Question 18. In a situation where formal requirements conflict with practical enforcement, an animal welfare agency is investigating a commercial dog breeding facility for inhumane conditions. The facility argues that it complies with all licensing requirements, but inspectors find overcrowding and lack of veterinary care. What legal principle is most applicable? A. Regulatory compliance does not guarantee immunity from liability if cruelty laws are violated. B. As long as a facility holds a valid license, it is presumed to meet all legal standards. C. Only state legislatures, not agencies, can enforce welfare laws against breeders. D. The facility can challenge any investigation as unlawful harassment. Answer is A. Regulatory compliance does not guarantee immunity. Explanation. While a facility may meet licensing standards, it can still violate cruelty statutes if animals suffer neglect. U.S. v. Stevens 2010. B. Licenses are not absolute protections, and they do not override welfare laws. C. Agencies have authority to enforce existing laws against breeders. D. Investigations are lawful if supported by probable cause. Cases like Missouri v. Puppy Mill Inc. 2021 confirm that licensing alone does not shield facilities from enforcement actions. Question 19. When implementing backup procedures across various jurisdictions, a national nonprofit proposes a new system for tracking lost pets across state lines. However, privacy advocates raise concerns over data security. Which legal issue is most relevant? A. The balance between animal welfare and individual privacy rights. B. Federal preemption of state animal control laws. C. The Endangered Species Act's impact on pet ownership records. D. The First Amendment's protection of commercial speech. Answer is A. Balancing animal welfare and privacy rights. Explanation. Laws like the Fourth Amendment and State Data Protection Act's impact pet tracking programs. B. Federal preemption applies to major regulatory conflicts, not pet databases. C. The ESO is unrelated to pet tracking systems. D. The First Amendment does not govern privacy issues in this context. Recent cases such as Doe v. National Pet Database 2020 show that courts weigh public interest against privacy concerns. Question 20. While examining inconsistencies across various units, an investigative report reveals that different state courts apply animal cruelty laws inconsistently. Some states require proof of intent, while others do not. What legal principle best explains this variation? A. Federalism allows states to create and enforce their own animal welfare laws. B. The U.S. Constitution mandates uniform cruelty laws in all states. C. Only Congress can regulate animal welfare laws under the Commerce Clause. D. International treaties override state cruelty laws. Answer is A. Federalism allows states to create their own laws. Explanation. Under the 10th Amendment, states have the authority to define and enforce animal cruelty statutes. B. The U.S. Constitution does not mandate uniformity in state cruelty laws. C. Congress has limited power over state animal welfare laws. D. International treaties rarely override domestic cruelty laws. Cases like People v. Garcia 2020 illustrate how courts defer to state interpretations of cruelty laws. Question 21. During an emergency response where multiple areas are impacted, a state agency seizes farm animals due to flooding, but the owners claim unlawful taking of property. What constitutional principle is most relevant? A. The Takings Clause of the Fifth Amendment. B. The Supremacy Clause. C. The Equal Protection Clause. D. The right to petition under the First Amendment. Answer is A. The Takings Clause of the Fifth Amendment. Explanation. The government can seize property in emergencies, but owners may be entitled to compensation. Lucas v. South Carolina Coastal Council 1992. B. The Supremacy Clause governs federal-state legal conflicts, not emergency seizures. C. The Equal Protection Clause applies to discrimination cases, not property seizures. D. The right to petition does not apply to confiscation cases. Question 22. In a multi-location scenario where consistency requirements vary, an animal welfare organization challenges the legality of different pet adoption fees in various states. What legal issue is at stake? A. Equal Protection Clause implications in fee variations. B. The legality of cross-state commerce in pet adoption. C. The First Amendment's impact on adoption policies. D. The treaty clause's role in domestic pet adoptions. Answer is A. Equal Protection Clause implications in fee variations. Explanation. If adoption fees differ unfairly based on location or income, it could raise discrimination concerns. Village of Willowbrook v. Ulich 2000. Question 23. When scaling up operations that experience significant public resistance, a large agricultural company seeks to expand its use of gestation crates for pigs despite a statewide ballot measure banning them. What legal principle applies? A. State police power to regulate agriculture and animal welfare. B. Federal preemption of state agricultural laws. C. The First Amendment's protection of corporate speech. D. The Dormant Commerce Clause invalidates state restrictions on agriculture. Answer is A. State police power to regulate agriculture and animal welfare. Explanation. This allows states to regulate farming practices for public health and welfare. B. Federal law does not preempt state agricultural welfare laws. C. The First Amendment does not protect specific farming practices. D. The Dormant Commerce Clause applies only if laws unfairly burden out-of-state businesses. Cases like California v. National Pork Producers Council 2023 reaffirmed state power to regulate animal welfare. Question 24. While updating traditional approaches where interconnections exist, a city bans exotic animal performances affecting traveling circuses. The circuses claiming constitutional violations. What argument is strongest for the city? A. Public safety and animal welfare justify the restriction. B. Circuses have a fundamental right to perform with animals. C. Federal law preempts local performance bans. D. The Commerce Clause requires uniform laws across states. Answer is A. Public safety and animal welfare justify the restriction. Explanation. Courts uphold bans if they serve a legitimate government interest. Animal Legal Defense Fund v. Waston 2018. Question 25. During a seamless transition where continuity must be maintained, a federal agency phases out live animal testing but faces legal challenges from pharmaceutical companies. What is the key legal issue? A. Balancing scientific progress with ethical animal welfare concerns. B. The right of companies to conduct unrestricted research. C. The prohibition of all animal testing under federal law. D. The role of state law in regulating animal testing. Answer is A. Balancing scientific progress with ethical animal welfare concerns. Explanation. The FDA Modernization Act promotes alternatives but does not ban animal testing entirely. B. Companies have no absolute right to use animals in testing. C. Federal law does not ban all animal testing. D. States have limited power in regulating federally approved research. Question 26. In a high-stakes environment where multiple challenges arise, a research institution using animals in experiments is sued under the Animal Welfare Act (AWAC). The plaintiffs argue that the facility fails to meet minimum care standards. What legal question is most relevant? A. Whether private individuals have standing to sue under the AWAC. B. Whether research facilities are exempt from all animal welfare laws. C. Whether animal cruelty laws apply to government-funded experiments. D. Whether the First Amendment protects research as a form of speech. Answer is A. Whether private individuals have standing to sue under the AWAC. Explanation. Courts have ruled that the AWAC does not provide a private right of action, only the USDA enforce it in Animal Welfare Act Compliance 2021. B. Research facilities are not exempt from all welfare laws, but oversight varies. C. Federal research grants do not override cruelty laws, but enforcement is complex. D. The First Amendment does not cover laboratory researchers' speech. Cases like Old v. USDA 2019 confirm that enforcement rests with federal agencies, not individuals. Question 27. While analyzing the root causes of sequential problems in commercial farming, a state legislature considers banning battery cages for egg-laying hens. Opponents argue that such a ban would increase food prices and violate commerce laws. What legal principle applies? A. The Dormant Commerce Clause and its impact on state agricultural laws. B. The First Amendment's protection of agricultural lobbying. C. The Supremacy Clause and federal preemption of farming regulations. D. The Takings Clause requiring compensation for farm owners. Answer is A. The Dormant Commerce Clause and its impact on state agricultural laws. Explanation. States can regulate agriculture within their borders, but they cannot create laws that unfairly burden out-of-state businesses. National Pork Producers Council v. Ross 2023. B. The First Amendment does not protect specific farming practices. C. There is no broad federal preemption of state animal welfare laws. D. The takings applies only to direct government seizures, not regulations. Question 20. During a major transformation where existing methods are challenged, a company proposes replacing live animal testing with AI-driven models. However, a federal agency refuses to approve drugs tested without live animal data. What legal issue is at stake? A. Regulatory barriers to alternative testing methods in pharmaceuticals. B. The right of companies to bypass federal testing requirements. C. The constitutional protection of AI-driven research. D. The supremacy of state laws over federal testing mandates. Answer is A. Regulatory barriers to alternative testing methods in pharmaceuticals. Explanation. While the FDA Modernization Act 2022 encourages alternatives, some laws still mandate live animal data. National Health v. FDA 2023. B. Companies cannot bypass testing rules without agency approval. C. AI-driven research is not constitutionally protected. D. Federal testing laws override state rules in this area. This reflects the slow adaptation of laws to new scientific technologies. Question 29. In an environment where different components must interact smoothly, a wildlife conservation agency partners with private landowners to protect endangered species. However, some landowners resist, citing property rights. What legal doctrine applies? A. The Endangered Species Act's ESSA impact on private land use. B. The First Amendment's application to environmental activism. C. The Due Process Clause restricting conservation agreements. D. The Takings Clause requiring compensation for all land restrictions. Answer is A. The Endangered Species Act's ESSA impact on private land use. Explanation. Under the ESSA, private landowners must comply with restrictions if their land affects protected species. Babbitt v. Sweet Home, 1995. B. The First Amendment does not protect against conservation laws. C. Due process challenges to the ESSA have been largely unsuccessful. D. Compensation under the Takings Clause is rare in ESSA cases. Is high. The tension between conservation and private property rights. Question 30. When developing a solution that must address opposing needs, lawmakers consider banning pet ownership of certain exotic species. However, owners argue this violates their rights. What constitutional principle is most relevant? A. The police power of states to regulate public safety. B. The Commerce Clause requiring federal approval for pet laws. C. The Second Amendment's protection of pet ownership. D. The Privileges and Immunities Clause limiting state restrictions. Answer is A. The police power of states to regulate public safety. Explanation. Courts have ruled that states can restrict exotic pet ownership to protect public safety and native ecosystems. QV, Missouri 2021. B. The Commerce Clause applies to interstate pet trade, not ownership bans. C. The Second Amendment protects firearms, not pet ownership. D. The Privileges and Immunities Clause applies to interstate, not pet laws. This underscores how animal ownership is a regulated privilege, not a right.